This module 1.13 deals with the topic as regards constitutional position of the President and his relation with the Council of Ministers. Now, this topic is of particular importance firstly because you will find that from this particular topic every year somehow or the other a question is being asked. So, that is one importance of this. Second importance is that this module deals with some of the most fundamental conceptions of the Indian Constitution as regards the parliamentary system of governance. Concepts like collective responsibility, the position of the Prime Minister, the position of the President, the position of the Council of Ministers vis-a-vis the President, the position of the Prime Minister vis-a-vis the Council of Ministers. So, these concepts altogether makes this topic a very important topic so far as our constitutional law syllabus is concerned, or polity in general. And thirdly, the concepts or provisions which are there in this chapter, this highly helps you in your knowledge regarding the general studies second paper, because many questions which have been asked in general studies too, particularly the conceptual questions has a very a strong bearing with this topic. So, the video lecture regarding this topic as well as the notes of this topic, if you find, is slightly on the lengthier side. The notes which have been prepared for this topic is almost about 18 pages. So, considering our standards, it is lengthy. So, so far as the video is concerned, it is also has to be a little lengthy because we have to cover so many subtopics or concepts under this module. So, I would suggest, if required, you can students can watch it in 2 sittings also, those who follows or those who listens to the listen to the video lecture. So, that's how it is. So, let's begin with this. The first concept so far as this topic is concerned is the position of the President. That is the first topic under this chapter. Now, so far as the position of President is concerned, we will be discussing particularly the provisions regarding part 5 of the Constitution, which starts from Article 52 and it goes up to Article 78. So, 52 to 78 deals with the position of the President. First, the provisions as regards the Vice President, which is not very important for this particular module, and 74, 75 which deals with the Council of Ministers, 76 Attorney General of India, which is also not important, 77, 78 has some kind of bearing with some of the topics and conceptions under this module. So, here we will be basically discussing Article 52 to 78. We will be referring to those provisions at short intervals as and when the context requires. Now, the first provision which we would be discussing is Article 53, that is Article 53 subclause 1, which provides or which establishes the position that the President is the formal and titular head so far as the executive is concerned. Now, as we all know the basic foundational concept that the Constitution talks about 3 different organs: the executive, the legislature, and the the judiciary. So, so far as the executive is concerned, Article 53, the marginal note says executive power of the Union. Clause 1 of it says the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. So, this provision expressly declares that the entire executive power of the Union shall be vested with the President. This executive power can be exercised by the President, or rather shall be exercised by the President directly or through officers subordinate to the President. So, here the concept which arises from this is that the President in fact embodies the entire executive power of the union. Now, we will see shortly that even though many functions are formally vested upon him, now the president is not required, or the constitution does not require the president to discharge those functions in his own discretion or individual discretion. The president always acts on ministerial advice. The prime minister and the council of ministers, they constitute therefore the real and effective executive, even though formally the executive powers are vested in the name of the president. So that is what Article 53 is. So even if a question, if there is a question which is asked regarding the position of the president, the formal power or the formal position of the president is declared in Article 53 subclause 1. But as we will see shortly, that the real and effective executive is the prime minister and the council of ministers, because it is according to their discretion, according to their aid and advice, that the president discharges his functions. So the president does not generally have any individual or personal satisfaction or discretion of his own. Now, in order to formalize the position of the president, or in order to confer some kind of majesty upon the position of the president, or in order to enable the president to discharge his functions properly, the constitution provides for some privileges which are available to the president. The first privilege is that the president is not answerable to any court of law. That is the first privilege. Now, this privilege in not being answerable to the court is available only in connection with performance of the powers and duties of his office, or for any or for any act which is done or purported to have been done by him. So if a president officially conducts any act or any executive action is taken in the name of the president personally, or the president himself, is not answerable to the court of law. Therefore, if we practically see a writ petition in the court of law which has been filed against the central government, even though all executive actions are taken in the name of the president is never made a party. It's always the Union of India, represented through the secretary of that particular department. So that is the practice of the courts. The second privilege is no criminal proceeding whatsoever can be instituted against the president, and no process for the arrest and imprisonment of the president can be issued from any court during his term of office. So criminal proceeding cannot be initiated. Along with that, no warrant of arrest or process of law. Process of law refers to summons, notices from the court, etc. Now, this privilege is available only during his term of office. Once a president remits his office, such privileges are not available to him. The third privilege is that no civil proceeding shall be instituted against the president in respect of any act done in his personal capacity or be instituted during his term of office unless 2 months notice has been given. So unlike criminal proceedings which are absolutely barred, warrant which is absolutely barred, process of law in connection with the criminal proceedings absolutely barred, but civil proceedings are possible, but we have to give a 2 months notice. Without servicing such notice, civil proceedings cannot be instituted. Now, these are the some of the privileges which has been granted upon the president in order to facilitate effective discharge of his executive functions. Now, this with regard to impeachment proceedings of the president, this privileges are generally not available. So if a president is being impeached in such proceedings, all records, documents, etc. can be called for by the parliament in order to ascertain as to whether the allegations which has been raised against the president, or if there is an allegation that the president has failed to act in accordance with the constitution, such records and documents can always be called for and considered by the parliament. There, in general, these privileges are inapplicable. Now, the important part as regards the president is why it is called that the president is a titular head or a formal head, or a post without any effective or real power. Why is it so? The first reason is that it is essentially a feature of a parliamentary system of government that the formal executive power shall always remain with the Prime Minister and the Council of Ministers. The President is generally a titular or formal head who is there with some kind of duties and responsibilities which to keep the executive in check and balance insofar as discharge of their powers are concerned. But generally the President does not act or do anything in his own or personal discretion. Now, if a question is asked as to whether the President is in fact a titular head or a formal head, or any kind of questions where we would be required to understand and address this aspect of the aspect as regards the position of the President, we have to mandatorily remember this particular constitutional provisions. These are very important, and instead of writing a vague answer, we have to always refer to these provisions and write those provisions in order to justify that yes, this statement is correct, that the President in a parliamentary system or in the Indian Constitution, the President is a titular or formal head. Now, the first is Article 53(1), which we have read out earlier, which says that the President shall exercise his functions directly or through officers subordinate to him. In terms of his provision, the President, the ministers and their officials are regarded as officers subordinate to the President. So, even though the President does not discharge any function in his discretion, still all other officers of the executive are considered as subordinate to him. So, this is one instance which establishes that the President is the formal or titular head. The second provision is Article 77 subclause 3, which says that the President can make rules for convenient transaction of the business of the government and for allocation of work among various ministers. This provision, which enables the President to make rules for conduct of business or transactions within the governmental framework, also establishes the President is a titular or formal head. The third provision is Article 53 subclause 3 subclause B, which says that the Parliament may by law confer any function on authorities other than the President, enabling such authority to exercise power in his own name. Therefore, this provision indirectly recognizes that it is the President who is the formal or titular head, but at the same time the Parliament may by law delegate such powers or functions to any other officers subordinate to him. Article 77 is another important provision, which says all executive action of the central government is to be expressed to have been taken in the name of President. So, unless the President was a formal or titular head, this provision would not have been there in the Constitution. This says that all executive actions should be taken in the name of the President. In the name of the President. So, whenever we see a particular order or a particular government notification issued by the central government, we will always see that it is at the bottom of such the notification or the government order, it is always written by order of the President or in exercise of the powers of so and so of the constitution, the president is hereby pleased to declare so and so. That is how the formats of central government orders are issued. The same we will find in case of orders issued by the state government, where we will find that it is always stated that by order of the governor, or the governor is pleased to declare or pleased to appoint so and so. So that's how the the orders are being passed. So it is in the name of the president or in the name of the governor in the case of a state. Now, Article 74 is one of the most important provisions in this regard, which has a very significant constitutional implication, because Article 74, the marginal note of which says Council of Ministers to aid and advise President. The article further reads, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall in exercise of his functions act in accordance with such advice. Subpara, provided that the President may require the Council of Ministers to reconsider such advice either generally or otherwise, and the President shall act in accordance with the advice tendered with such reconsideration. Clause 2. The question whether any, and if so what, advice was tendered by ministers to the President shall not be inquired into any court. Now, therefore, it leaves no room of doubt that this provision expressly makes the President a mere titular or formal head, and it makes the Council of Ministers with the Prime Minister as the real and effective executive, because it expressly says that all decisions or all functions of the President has to be discharged by the President in accordance with the aid and advice given by the Council of Ministers with the Prime Minister. Now, this provision, that is Article 74, is, as we have said, is of some constitutional significance, and hence we will discuss this in a little detail. Now, Article 74, as we see today, as I have just read out, is something which has seen some kind of modifications or evolutions throughout the years. It has been amended twice. The 42nd Amendment Act has made certain changes, and the 44th Amendment has also made certain very important changes, to which will come in a short while. Now, the first question in this regard is how this article looked like before 1976. Before 1976, Article 74(1) provided that the Council of Ministers shall aid and advise the President in exercise of his functions. So, that is the basic concept of this provision, that is all right. 74(2) previously, prior to 1976, declared that no court can inquire into the question whether any, and if so what, advice was tendered by the ministers to the President, thereby making such advice non-justifiable. 74(2) as it is today, it was also there before 1974. The only implication of 74(2) is that the court cannot go into the advice which has been tendered by the Prime Minister and the Council of Ministers to the President. That advice is beyond the scope of judicial review. The court can't go into that under any circumstances. Now, in Ramjaya Kapoor, this provision came under consideration. It was observed that the Indian system, having adopted the British system of parliamentary executive, the President is only a formal or constitutional head, and the real executive power is vested in the ministers or the cabinet. The Supreme Court used a very fine expression. Here the Supreme Court said the Council of Ministers is a hyphen or a buckle which fastens the legislature and the executive. Now, this concept or this expression is very important. Now, as said, as described by the by the Supreme Court, the Council of Ministers was described as a hyphen or a buckle which fastens the legislature and the executive. Why it is so? Now, so on the one hand we have the legislature, and on the other hand we have the executive. The executive is formally headed by the president. The president acts in the aid and advice of the Council of Ministers. So, the entire executive function, which is headed by the president, is being discharged on the aid and advice of the Council of Ministers. Now, as we all know, in a parliamentary system, the Council of Ministers is also a part of the legislature. So, the Constitution itself therefore establishes the system of collective responsibility, which we will discuss in a while, which says that the Council of Ministers and the Prime Minister himself, along with the Council of Ministers together as a body, is always responsible to the legislature. So, the Council of Ministers on the one hand aids and advises the president as regards his discharge of executive functions. So, the entire executive functions are being discharged by the on the aid and advice of the Council of Ministers. On the other hand, the Council of Ministers are always answerable or responsible to the legislature. So, this concept of parliamentary system therefore establishes that the Council of Ministers is a buckle or a hyphen which connects the executive as well as the legislature. So, this is a fundamental concept here which we should be very clear with. Now, this, whenever a question is asked, you can explain this concept by drawing a kind of a chart or a diagram, whichever suits you. You can explain this in a pictographic manner, which will kind of create a good impression about your understanding. Now, the second important case is UNR Rao versus Indira Gandhi. The Supreme Court emphasized that the provisions of the Indian Constitution must be interpreted and understood in the light of the British conventions, which also has adopted the parliamentary system and which also considers president as a titular head only. Now, in Shamshed Singh versus State of Punjab, the Supreme Court observed that the constitutional requirement of the satisfaction of the president in exercise of any power or function by him is not his personal satisfaction but the satisfaction of the Council of Ministers. So, these three cases lays down those provisions or those words which we are now have or which we have already discussed informally in course of this video. So, we would remember these cases only to substantiate those general words or concepts, in order to write a good answer or to give an impression to the examiner that what we are writing is not our own words, but it has been established by certain judicial decisions or authoritative pronouncements of the Supreme Court. Now, therefore, along with Article 74, we will also here remember Article 77, which is also a very important article so far as the position of the president is concerned. Article 77 lays down that all executive action of the government of India shall be expressed to be taken in the name of the president. So, we have discussed in the earlier slide that so far as the position of the president, Article 77 subclause 3 and Article 77 as such, 77 clause 1 in fact, is what we should thoroughly remember in order to describe the position of the president. Now, here we will also discuss the two amendments, that is the 42nd and the 44th amendment, which are quite important because of the reason that in 1976 it is the 42nd amendment which made it explicit that the president shall act in accordance with the advice of the ministers in exercise of his function. So, this was previously implicit in the constitution, but the 42nd amendment has only made explicit what was implicit before. The 44th amendment was of some importance because we have already seen that in the backdrop of the emergency, the 44th amendment was enacted, which tried to put in some kind of flexibility or some kind of more safeguards in the constitution to preserve the basic values of rule of law and democracy. So 44th amendment inserted the second subclause within Article 74, which reads that the President may require the Council of Ministers to reconsider such advice either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. This subclause means that if an advice is being tendered by the Council of Ministers to the President, earlier the President at the first instance had to act upon that particular aid or advice. There was no discretion of the President to discard or to disobey or to disregard that particular advice. But subsequent to the 44th amendment, a flexibility was brought in within the framework where the President, if personally he thinks in his discretion that a particular advice which has been tendered by a Council of Ministers are not adequate or not reasonable or not sensible or not in the best public interest of the country or not in accordance with the Constitution, he can then resend that advice back to the Council of Ministers, who shall then again reconsider that advice. Now, once the Council of Ministers reconsiders that advice and sends it back to the President again for the second time, that becomes binding on the President. Now, this time gap which intervenes between the sending back of the President, the second reconsideration by the Council of Ministers, and then again sending back to the President, this particular time gap practically is of great utility because lot of things can happen within this particular period of time. The Council of Ministers may change their opinion, the political situation may change in the country. A decision which was thought as appropriate while sending it for the first time may not appear to be appropriate while sending it for the second time. So this time period, which has been indirectly incorporated in the Constitution by way of making a provision for reconsideration, is of great significance. One instance of this is the decision of the Council of Ministers regarding imposition of presidential rule in Uttar Pradesh during the year 1997. There are many such instances where we will find that an advice which was transmitted to the President for the first time has subsequently been denounced or has not been taken once the President has sent for reconsideration. So this is also one such instance. We will remember just one or two instances for this in order to demonstrate once a question is asked on this. So here the government has recommended imposition of presidential rule in Uttar Pradesh under Article 356 of the Constitution. The President thought that such imposition may not be in the best interests of justice or shall not be in accordance with the Constitution. That may be due to other political exigencies or factors which the President had in his mind. Now, once the President sent that particular proposal back to the government had did not pursue that advice once more to the President, because within that span of time the government had already won a vote of confidence in the assembly. So this way the provision for reconsideration, which can buy some time for the President or for the Council of Ministers, can change the political situations in such a manner that the first recommendation or the first aid and advice which was sent by the Council of Ministers may not be as much significant or as much relevant as it was. So this is a practical utility of this particular amendment or this particular provision as regards reconsideration. Now, therefore, as of now, we will see that the President really does not have any individual or personal discretion provided by the Constitution. However, there are certain matters where the President appears to have a kind of a marginal discretion. Now, the one instance of this is the appointment of the Prime Minister. Now, in a situation where it shall appear that after election the majority party which has won a election has won with a very thin majority, or in fact there is a coalition government, where it is not clear which is the most strongest party within the majority. The president has some kind of a limited discretion to pick up and choose the prime minister, because it is the president who shall appoint the prime minister, and upon the advice of the prime minister the president shall appoint the other council of ministers. That is the constitutional provision. So the appointment of prime minister has to be done by the president personally. Now, in a case where a fresh election has been conducted, where a proper council of ministers is not in existence, which is required in accordance with the constitution, the president has a marginal, discretion so far as appointment of the prime minister is concerned. He may consider picking or choosing a person who would thereafter, enjoy the confidence of the house, because the prime minister has to enjoy the confidence of the council of ministers. The entire council of ministers along with the prime minister has to subsequently enjoy the confidence of the house, because it is the house to which they shall be responsible. So the president has a discretion to pick a person who shall enjoy the confidence of the house. So here the president has a marginal, a discretion. Now, so far as position of the president is concerned, these are the relevant provisions, these are the relevant case laws which we are required to keep in mind. Now, moving further, we shall discuss the powers and functions of the executive which are exercised by the president. We should read it as exercised in the name of the president.